Joining us now is Joseph Tully, a defense attorney at Tully and Weiss. Joseph, thank you so much for joining us this morning.
Yes, thank you for having me. Good morning.
We often hear of these cases, Joseph, of people, pleading not guilty by reason of insanity. The fact that Nick Reiner has this history of schizophrenia even before the murders took place, how prominent would that play a role in the case moving forward, or even during this appearance today?
Sure. So it looks like that's the only defense that they have. So just to look at it pragmatically, they don't have they know probably who did it. And so because there's not a defense of he didn't do it or he had self-defense, the only defense they have is not guilty by reason of insanity. So right off the bat, you know that's what the defense is going to explore. However, in this case, sadly, there is a documented history of mental illness, of addiction, which a lot of times people don't realize. It's called dual diagnosis. People who have mental health issues also can have addiction issues, and they have to be treated both simultaneously. So I look at his history of addiction and going into treatment as other further sign of his mental illness, and that will be very prominent in court throughout the defense of this case.
But how effective is a mental health defense in a case like this? We've seen, documentary shows, read about people pleading not guilty by reason of insanity, for this mental illness. But is that an effective defense here, especially when you have, his parents killed in such a brutal way here?
Sure. So the law shouldn't be looking at the facts, but I think you're right to do so because the law is run by human beings, and human beings have emotions. We're not always pure logical beings. So it used to be when I first started practicing that not guilty by reason of insanity wasn't tried that often, or if it was, you didn't go very far with it. In the last 5 to 6 years, I would say, maybe a trend of 10 years, not guilty by reason of insanity is beginning to have teeth again in court. And you can win cases, or you can get a not guilty by reason of insanity where there is sufficient evidence of insanity in a case. It's very hard to get. You can't just have a mental health issue and commit a crime and think you'll get away with it. The qualifications to qualify for defense of insanity is very stringent, very hard. But now, if you can get it, if you can reach those levels, which I think they can do here, then you can get an acquittal. And it's not that you walk out of jail, everything's fine. There's still consequences, but still, the system, the criminal health system in general, is starting to get more enlightened on mental health issues.
The arraignment was scheduled to begin at 8:30, so about 45 minutes ago. We're still waiting on word on what's happening inside the courtroom. He is also facing the special allegation of using a dangerous and deadly weapon. First, talk about the charges and what punishment that carries, along with the special allegation of using a dangerous and deadly weapon, which was likely a knife here in this case.
Sure. So the biggest charges here are the 187s, the first degree murder, the murder cases, because those carry life sentences. Now, he is alleged to have used a knife, and there is a special allegation or an enhancement in California that prosecutors can charge. However, it adds very little time. When you're looking at 25 to life for each murder, or 15 to life if it is a second degree, then the extra time for using a knife isn't that much. I believe that it's only 1 year added for each charge. So the using a knife isn't too significant. I think the bigger play here is on the murder charges. Those will control exactly what happens in this case.
So then, if it only adds a year, why do you think the prosecutors then added it? Is it just you throw everything at the case and sees what lands after that?
Correct, yes. Prosecutors, sometimes they overcharge, sometimes they undercharge, sometimes they get it just right. But in general, their job is to charge something as many ways as possible, because they have to sort of insulate their their result. They don't want to charge something and get nothing. So the more they throw out something, the more likely it is that something will stick.
What are you watching for as an attorney in this case as it plays out in Los Angeles right now and likely over the next year or so?
Sure. So I would on that note, I would agree with you that very serious cases, life cases, take about a year plus or minus to get to trial. So it might take, 6 months. It might take a year and a half, but a year is a pretty good indicator of when a case should go to trial if it's very, very serious. Again, it might take 5 years. But what I'm looking for specifically as an attorney is to see whether or not rather than enter a not guilty plea, the defense enters a not guilty by reason of insanity or declares a doubt to his mental state right away. So I've had cases, very serious cases, murder, in fact, where I had a doubt as to my client's sanity, and I never entered a plea in that case. And because of that decision, it played out a little bit differently. So I would be looking to see whether or not they declare a doubt as to his sanity before entering a plea, or if they enter a plea and then it's not guilty by reason of insanity.
All right, Joseph Tully from Tully and Weiss. We are watching and waiting to see what happens in this arraignment, but we will see what happens here shortly when information comes out of the courtroom. Joseph, thank you so much for joining us this morning. We appreciate it.
Thank you. Take care.
All right.